not. All right, we're here for non-jury trial today. Are we ready to proceed?
Yes, Judge.
All
Likewise,
right.
Your Honor.
Anybody want to give opening statements?
Judge, the people will waive opening statement.
Defense will likewise waive, Your Honor.
All right. You may call your first witness.
Thank you, Judge. The people call Sergeant Jordan Irbies to the stand.
Sergeant Irbies, please unmute your device for me and raise your right hand to be sworn. Sergeant Irbies, do you swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. I know you've testified before, so I don't need to give you any direction. Is that correct?
Yes, Your Honor.
Thank you. You may proceed, Ms. Woods.
Thank you, Judge. Sergeant Irbies, could you please state your name again for the record?
Sergeant Jordan Urbis, E-R-B as in boy, E-S.
And where are you currently employed?
Washtenaw County Sheriff's Office in the Police Service Division.
Okay. And were you employed in that capacity on November 17th of 2024?
I was.
On that date, were you involved in an investigation involving Lawrence Buckner at 1501 South Huron Street in Ypsilanti Township?
I received a complaint from him, yes.
What do you mean by that?
I was asked to call him in regards to a trespass notice that was served to him earlier that evening.
And did you call Mr. Buckner?
I did.
What phone number were you provided to call?
734.
Thank
And
you.
why were you given the task to call Mr. Buckner?
Buckle up, guys. Today we're diving into a trespass mix-up that turns into a threat case. Non-jury, no openings from defense. The court wastes zero time. The judge sets a crisp pace and signals we're staying on facts. Prosecutors ready. Defense is quiet, always a tell. The air is tense before the first oath. You can feel a storm brewing behind polite courtroom ritual. This is the calm before the audio receipts. Stay sharp. Foundation is everything in bench trials.
Just give him the correct information.
He asked to be called in order to make a complaint about being served the improper address.
Oh, so Mr. Buckner was complaining, so you were just
Yes.
calling to follow up on that complaint?
He asked to speak to a sergeant, and I was the one that was on duty at the time.
I see. Do you recall what time you called Mr. Buckner?
I believe it was around 1:30 a.m., somewhere in that time frame.
Okay. And are you familiar with Mr. Buckner's voice?
I am.
And when you called Mr. Buckner, was this call recorded?
It was recorded on my body-worn camera.
Judge, may I share my screen?
What are you sharing?
The phone call, it's on his body-worn camera. I just want to lay foundation.
All right. Any objection?
In time that would know that the trespass was served to the improper address.
And do you see Mr. Buckner on the Zoom today?
I do.
And could you please describe him to the court? Or
He's wearing a black t-shirt with a chain. His Zoom video is labeled.
All right, guys, the scene locks in. Wrong address on a trespass, and Buckner wants answers. Sergeant confirms the call was only to address a complaint. Small clerical error, massive ego fuel, classic spark. The date and location matter. Credibility starts here. Prosecution frames it as routine follow-up. Defense hopes mix-up softens motive and tone. Watch how simple facts become leverage. Every clean detail now will cut later.
We have two clerks that work for us.
okay. And did you take what Mr. Buckner said to you as a threat on Deputy Clark?
I did.
Okay. And when a threat like that is made to a law enforcement officer, what are you required to do?
There's not any specific requirements, but I made sure to notify Deputy Jay Clark so that he was aware that the threat was made. And then due to the likelihood of it, if it was going to be carried out, it would possibly be that night. I notified the other deputies on shift in case something occurred with Mr. Buckner.
Did you believe that threat that Mr. Buckner made?
Yes, considering it was made to a sergeant and it was pretty brazen, and it's well aware of who we know who he is, I did take it as a credible threat.
Okay. And how did this threat on a fellow law enforcement officer make you feel?
Concerned me for the safety of my deputy in the event that he was reserved that trespass notice, or in the event that they did come in contact with him in the community again that later that evening or that week.
Do you believe that this threat was intended to frighten, intimidate, or annoy or disturb your peace?
I do.
Your Honor, I'm going to object to that question as speculation and or calling for legal conclusion.
Response.
I'm just asking for the officer to elaborate on how that made him feel. I can rephrase my.
All right, guys. Now we set the chain of custody on the body cam. Officer shows the dial number. Smart for verification. Judge admits the exhibit. The door opens for the receipts. 30-second buffer with no audio. Procedural note, not a glitch. This is how you bulletproof a recording. Process is not equal to drama, but it wins trials. The table is set. Only the call can help or hang him. Let's roll into what was actually said.
He was willing to make such a brazen threat, knowing that he was talking to a sergeant, knowing that he was calling to make a complaint. The credibility of that threat to me was pretty substantial. It's not something that I get very often when somebody asks me to call them, that they're going to tell me that they're then going to beat up or attack one of my deputies. That's not typical.
Mr. Lebo?
Thank you, Your Honor. Deputy Urbis, one of the things you said on the phone call was that you knew Mr. Buckner was lying to you. Is that correct?
Correct.
And what you were indicating, Mr. Buckner, that you believed he was lying to you about was whether he had encountered Deputy Clark. Is that correct?
I believe it was whether Deputy Clark had a problem with him specifically or not.
One of the things you said in that call was that he hadn't been at the sheriff's department long enough to have any contact with Mr. Buckner. Is that correct?
To have significant enough contact for him to have a vendetta against Mr. Buckner, yes.
Fair to say that you were incorrect and that Mr. Buckner had contact with Mr. Clark.
Yes, he had contact. I don't believe I refuted that he had contact.
So fair to say that Mr. Buckner was not in fact lying to you?
I mean, it depends on how you're interpreting what Mr. Buckner said. So the reason that I said
Certainly.
Okay.
So additionally, you said earlier that you took this threat seriously.
Correct.
Now on the video, we heard you laughing immediately after you stated out loud that it was a threat.
Correct.
Would you generally laugh?
All right, guys. The call starts civil and slides into heat. Addresses clash. Gas station versus pizza shop. Technical but telling. He disputes scope like it erases conduct. Officer keeps it cool, clarifies verbal service. You can hear frustration curdle in attitude. This is where intent starts peeking through. Every word on tape narrows the wiggle room. We're inches from the line, then over it.
Turned to frightened. Do you remember that?
Correct. Yes.
Why did you make that change?
Well, I can feel frightened at the same time that I can feel concerned for my deputy's welfare.
You certainly can, but I'm asking why you changed your phrasing the first time the question was asked to the second time the question was asked.
I don't have a answer for that.
Did you change that phrasing as a result of how you felt it would influence the outcome of the case?
No.
Okay. Now, after Mr. Buckner made that statement, because he approached me at the pizza place, I beat the F out of him, he hung up right away, didn't he?
Correct.
Did he try calling you back?
No.
Okay. And how did you determine that the he was talking to was Deputy J. Clark? Was it anything other than the context of the call?
I believe he said Deputy J. Clark in the phone call. He said Deputy Clark in the phone call, identifying him.
At the end of the call, I heard was he. Did you hear something different?
I'd have to re-listen to the body cam again, but I believe that he did say Deputy J.
Okay,
Clark.
so why don't we play it again? And Your Honor, may I share my screen to share the body camera? Tone just heard.
Yes.
Thank you.
Yeah, hello.
Hello, Mr. Buckner, Sergeant Herbs with the Sheriff's Office. What can I do for you?
Oh, and then I don't understand. Like, I got a trespass, and and it just happened to be by the same officer.
All right, guys, here's the break point, the explicit threat. If he approaches me, I'm going to beat the underscore out of him. No ambiguity, direct target, present tense. Officer identifies Deputy J. Clark, context locked. This isn't venting, it's actionable language. Credibility rises when the threat names a real actor. Bench trials love clean, provable moments like this. And now the fallout begins.
Well, he has to have a beef because I didn't talk to him a few times.
Okay.
So outside of that, you don't know what transpired because you ain't been everywhere. But this trespass don't exist. It's to the wrong building. And,
Okay. What address did he trespass you to?
they trespassed me to 1024 E Course Road.
Okay. Well, that is incorrect. It's 350 South Ford. It's the Oklahoma.
Yeah, so they put the wrong thing on there. So this
Okay.
one don't exist. So, they just got to reserve me or whatever.
No, we don't have to reserve you. I just have to verbally serve you. I don't have to serve you a piece of paper. So you're trespassing from 350 South Ford Boulevard. If you'd like another piece of paper, then you can meet me and I can give you another piece of paper.
I'm just making, y'all aware because, I am going to be still, I'm not banned for the pizza place. So, I'm not going to deal with this fake ass Islamic bullshit. You know what I'm saying?
Okay. Well, you're trespassing from that premises there.
No, the premises is for the gas station. That's the address. The address to the pizza place is a whole different address.
Okay.
Okay, so that's a whole different address.
Okay.
So, all this little bullshit, I ain't gonna deal with it. Because he approached me at the pizza place, I'm gonna beat the fuck out of him.
That you did at the end. What kind of laugh would you say that was?
It was more out of shock than anything else that he had just said that and then hung up.
And he hung up the phone on you, correct, after he made that threat?
Correct.
Okay.
All right, guys, response matters. Watch the protocol. He alerts Clark and the shift. Timing shows urgency. He explains why brazen threats to a sergeant hit different. Concern and fear can coexist. Impact over semantics. Credibility is built on what you do after the call. Documentation plus notification equals prudence, not panic. The state frames this as risk management, not drama. The narrative is tilting toward real threat.
And did you end up reporting this after this happened?
Reporting it in terms of,
For charging.
yes,
And why did you do that?
because I believe the threat may be credible.
I have no further questions, Judge.
Thank you, Mr. Lebo.
Very briefly, Your Honor. Sergeant Irby, were you laughing because you were looking forward to submitting charges against Mr. Buckner?
No,
Okay.
shocked
Fair.
reaction.
Fair to say that throughout the conversation with Mr. Buckner, far before you made that statement, you were generally fairly impatient with him.
Yes.
Fair to say you're not a fan of Mr. Buckner?
I wouldn't describe it as that. I've had a lot of dealings with him.
Thank you. I have no further questions.
Thank you. May this witness be excused.
Yes, Judge.
Yes, Your Honor.
Thank you, Sergeant Erbs. You may be excused. Any further witnesses in the prosecution?
No, Judge, and the people rest our case.
Thank you. Any witnesses from the defense?
No, your defense rests except for closing argument.
All right. Did you want to talk?
All right, guys, the defense counters with precision. Why laugh after a serious threat? Optics matter. Concerned versus frightened. Language gets cross-examined. They're planting doubt about sincerity and stakes. If feelings shift, was the danger overstated? This is how you chip at credibility without touching the tape. A bench judge weighs tone as much as text. One wobble can loosen the whole beam.
Case of Mr. Lawrence Buckner.
Thank you, Your Honor. I have a chance to speak to Mr. Buckner. Additionally, and I would like to just adhere him to place the testimony on the record. Mr. Buckner, have you decided to waive your right to testify in this case?
Yeah.
Thank you.
All right. So, Mr. Buckner, you fully understand you have a right to testify, at which time anything you say can and will be used against you in a court of law. You're choosing to waive that right and not testify today? Is that you're choosing to not testify today and you're not going to exercise your right to testify? Is that correct?
Yes.
All right. All right. I guess we can proceed with closing statements with the people, please.
Thank you, Judge. So, Judge, we heard testimony from Sergeant Irby's. We know this happened in Ypsilanti Township, and we know that the defendant made these threats through a phone. The telephone number was also put on the record. We actually saw the phone call that was used to communicate between Sergeant Irby's and the defendant, Mr. Buckner. Second, that when communicating with Sergeant Irby's, the defendant threatened physical harm to another person or to any person. It doesn't even really matter who that person is. Sergeant Irby's believed that that person that he was threatening happened to be Deputy Clark because he spoke about Deputy Clark. He actually said,
All right, guys, replay time. Context under a microscope. Deputy Clark's name lands from Buckner's own mouth. Defense hunts for nuance. The audio stays stubborn. Intent lives in words, delivery, and timing. Did he mean it, or just puffing steam? Bench trials parse that line with surgical patience. Your take? Drop it in the comments. Like the video, subscribe for more courtroom breakdowns, and we'll see you in the next video.
threats that were made by the defendant directly to a sergeant of a law enforcement agency. Judge, what these people do day in and day out is dangerous. Threats should not be taken lightly, and they were not taken lightly by Sergeant Irby's. When Sergeant Irby's has had dealings with this defendant before, he knows him. He believed that that was a threat. He reached out, let Deputy Clark know about those threats. He recorded that phone call. And then he did what he was supposed to do, and he went forward and had this case looked at for charging, Judge. That shows me right there that this sergeant believed that the defendant made those threats with the intent to frighten, intimidate, threaten, disturb the peace and quiet of the sergeant.